have a quorum. Good morning, everyone. Citizens can be heard. I don't believe anybody's signed up. Consent agenda, we have 2 items.
Judge, I'd make a motion we approve the consent agenda.
Motion made.
Second.
Second. All those in favor?
Aye.
Unanimous. Discuss, approve, disapprove allowing Aransas County Medical Services, Inc., a nonprofit property owner of Enterprise Medical Complex, 400 Enterprise, to contract with Aransas County for the repavement of their parking lot by road and bridge at a cost of $20,000. As you know, Aransas County Emergency Medical Corps is a nonprofit and has served this county well for many years, and they've asked us for help, not cutting any expenses. They'll pay for it, but they would like our help in paving their
Judge,
parking lot.
I would like to ask our attorney, is that in accordance with local government code that we can do work on somebody else's private property?
If it's for a public purpose, you can, and for a nonprofit who is serving other nonprofits in that area,
I thought we were strictly limited to other taxing entities.
so for public purpose, you can.
Fair enough. That's some advice of counsel.
Motion
Second.
made
Second.
and seconded. All those in favor?
Aye.
Unanimous. All right, discuss, approve, disapprove options approved by Texas Department of Emergency Management for the Future of Hazard Mitigation Grant Program Project 4332-017, Fulton Beach Road Shoreline Resiliency Grant. Okay, John, come on up. But as you know, things were going along, and then we heard from the residents that they had problems with it. So we're back to, I believe, square one, more or less.
We're kind of back to square one. At this point, I presented to you guys 3 options. The first option is we move forward with the project as it's planned.
This was vetted by Texas Department of Emergency Management.
Right.
Okay.
We had a conversation with them after the meeting over at the NAV district. The first option is we move forward as is planned. The second option is to transfer the permit to another entity. And the third option would be to, and Tatum as well, I was very concerned that we might have to pay it back. But Tatum said to us that if you want to put it on the shelf for a while, till the next hurricane or next event, and take it off, adjust it, make it work for the current situation, we'd be glad, and we'd be with no penalty, no problem. So my opinion is that that's what we do.
John, just a quick question. The damage that was done here recently by the storm surge from Hannah, that's covered by FEMA?
We have, I guess if we made a claim for it, the jurisdictions, the road damage, we had road damage, they could claim it. I guess you has to get the $40 million. We were talking about that this morning.
Okay,
In the
so
state.
we just have to reach the $40 million threshold?
The state does, yes.
The state does? Otherwise, then we have to pick up the cost?
Yes.
The problem here is that the damage that was repaired out there, which entity, which jurisdiction was it in?
David, did we do some of the damage repair?
We did some of it, most of the worst damage was in the town of Fulton.
Are they going to pick up the cost of that if we don't get a grant for it?
Yeah.
Fair enough. Thank you.
Any questions?
So you don't want to consider transferring the project to
what-
another
The
NAB district, say?
The problem we have is we have all the jurisdictions are involved. So who do you transfer to? The road portion of it it's primarily Rockport, City of Rockport, and partially Town of Fulton. The jurisdiction in the water is the navigation district. Who would be the best entity to transfer it to?
Can we transfer it partially to the NAB district, or does that work?
I don't think so. No, not in a grant, not a federal grant.
Can we not enter into a partnership with them they do the water part, we do the road part, or something
No.
like that?
We were trying to enter into MOUs for all of that. And this is where we're at.
So if in fact you were to transfer it to somebody that didn't have eminent domain, or if you needed more right of way and things like that,
Right.
that could possibly be a
If NAV
problem.
district had the permit, then the roads are, and the roads are in the two different jurisdictions.
Exactly.
And at this point, John, or to change it to something that the
What-
residents would agree with is gonna,
The
we're gonna have
problem,
to expend more funds to re-engineer it. and
right,
permit.
well, that would cost, who's going to pay for that? The problem we have is this is a mitigation grant. This is not some, it was meant to mitigate against what we saw last weekend or weekend before last, is to put, the abatements were made to break the waves out there and not up against the road where you saw the waves breaking over the road. This is an approved, the reason why these projects were accepted and approved in the first place is because they fit what FEMA wants it to be. And so that's why they were picked, boom, just like that, they were approved.
In your opinion, with the small hurricane that we had,
Yeah,
if it had been installed, we would have received little or no.
you would have seen a lot, yes, you would have seen a lot less damage. If you look at pictures of the seawalls at Fulton Harbor, the waves are breaking out at the seawall and the harbor is relatively smooth, relatively calm compared to what was going on around it.
Don't they have breakwaters at the harbors, but they had boats down, sunk and.
Well, that
waves
was
over top.
probably more from water getting in the boat
For
than it
whatever
was.
reason, when they built Fulton Harbor, they didn't build the wall high enough. I mean, it's, you know, it goes under frequently.
There's,
In that type of storm deal, it's not anywhere near the height of what Rockford is.
and this was the outer bands of a 20-year storm. This was not a big storm.
I know down on Shell Ridge, it took several of the piers out down there.
Mhm.
I had one that I've been working on for a long time. I mean, it just wiped it out.
Saturday morning at Shell Ridge, you couldn't get anywhere near Shell Ridge.
Right.
You couldn't get anywhere near it.
And I visited with those people down there, and they want to go ahead and proceed, but I understand we're gonna have another public hearing there.
Well, the core part of the Army Corps of Engineers permit process is do a public outreach.
Okay, now, if we decide to shelve this or do somewhere else, it only is this part of the total project,
There's 3 projects. This is this project.
not Shell Ridge or.
No, those are still, I've only had one person call from Lamar and she was buying a lot. Seemed very knowledgeable about her questions. It was more of, but she said she was buying a property versus, but
What's the total grant for this particular project?
3.1 million.
3.1
And that's a general number, yeah, but it's $3.1 million.
to raise
To
the
start,
road?
that's to start with.
We spent 248,000 of the
But I
3.1.
mean, the whole project, raising the road and the whole smear,
Yeah, 3.1 million.
it can be done for that?
Yeah.
And the offshore? barrier?
Offshore abatements, yeah.
Okay, fair enough.
So our recommendation is we put it on the shelf.
Tommy's got a question.
Third option is that we, with Tatum, will accept is we can take the permit, we can take the plan or the grant and put it on the shelf until the next storm. We have another natural disaster declaration, we can take it off the shelf and reapply it.
Is there generally a time limit on that?
No, I don't think so. They didn't say. No, when Aransas County declares a natural disaster, like we did for Harvey.
So,
Nope.
so whenever we get through being a disaster, that project, if it's not already accepted and underway, goes away, or goes onto the shelf,
Goes on the shelf.
then you have to have another disaster before you can take it off
Right.
the shelf.
Declared disaster, yes.
But the funding, you're not gonna put the funding on the shelf, just the
It's the
package.
funding. It's the grant itself. It's a mitigation grant.
At the very end of that option 3, John, it says FEMA Tatum would assess the project and allow a restart based on damage and funding available at that point in time. So even if we were to try to wait to do that, but they may not have any funding
They
for
might
it, is
not
that?
have money.
Well, there'll be a whole new round of grant funding coming in from FEMA.
Okay.
So we'd be that far along on it. We'd already done our BCA. We've already done everything.
John, is shelving it something we do right now, or
We can wait a little bit, I think. We just,
I would say, mention it to the other entities if they want to go to the expense of picking it up. Let them mull that over between them.
I think we have a time between now and the 14th for input from the public, if I'm not mistaken.
So we could table it till then.
Yeah.
What happens to the 248,000 that we've already?
we don't
spent?
have to pay it back. We were scared to death that that would be the case.
Yeah. Well, Judge, this is William. Would you like for me to comment?
Yes, go ahead.
Okay. At this point, the 248,000 we've already spent is water under the bridge, and Tatum understands, and FEMA as well, that we don't have to go forward with the project if we opt out. We would have to go through a wind down of the project and formally close it out and ask them to put it on the shelf. As John stated, it would be for a future event. Hannah is basically in the process of trying to reach a damage threshold. And that's going to be tough to do. So I don't anticipate very much funding being available from Hannah. But let's just say we would get another major storm in the future, like a Cat 4 or 5. That would be a whole different conversation. And so we would basically take the project from off the shelf at that point and rerun the BCA, benefit cost analysis, and submit it into the process to compete for future hazard mitigation funds at that point in the disaster. So yes, we can put it on the shelf, no harm, no foul. But then if we take it off the shelf in a future event, it would have to compete for funding just as we've competed and got it this far this time.
My big concern about putting it on the shelf is that this was a very minor Category 1. And probably whenever it got to us, it's probably a large tropical storm. But what happens if we get a 2 or a 3? What's it going to do to that road? And that's going to change all of the figures. That's going to change everything. We're going to have to go back to square one to do it.
Go ahead, Jack.
I appreciate what was said in that meeting and everything as far as the aesthetics and stuff. I think that's ugly too. But I'm really torn on this because of the fact that I saw on Shell Ridge what just this minor storm did without the thing. I saw what it did on Fulton Beach with 75-mile-an-hour wind and not even a really high tide, but just a
3 or 4 foot.
And I'm scared to death to leave it on the table because I think we're going to have other storms. And if we wait 5 years, 10 years, 5 months, whatever it is that we wait, and we get a Category 2 or Category 3 in here, we're talking about millions and millions of dollars in restoring Fulton Beach Road.
And
Exactly.
Commissioner, I don't think that you're going to really even have to have a storm to see some of the continued damage to that road out there with rising sea levels, which everybody is projecting. I mean, even a high tide now, you got water sometimes that's standing on that road that's going over. So we're going to wait, and that road's going to become more damaged, continue to damage. Now, after having said that, though, has anybody presented an alternative plan, a design plan to you?
No. Yeah, a lot of people came to that meeting that the NAB district held for the Fulton Beach Road residents. I may have missed it. I can't remember anybody speaking in favor of the project. They all understood we badly need a solution to the road, the storm damage on the road, to the erosion. But the almost universal reaction was this solution does not work.
But part of the problem is this solution it's been around for 10 years. But the solution is and two things. There's three. It's abate the waves, secure the shoreline, and make the road where you can raise the road up. the project, what we did from the original plan was we raised the road up. That was FEMA's requirement to bring the road up.
Right.
So it's a three-piece plan. And this is what FEMA accepted is the plan for mitigating future storms. They're trying to mitigate loss of road, loss of utilities, loss of access. That's what their plan is. And this is not a plan it's not a carte blanche thing. You can't just go in there and plop it, whatever you want to put in it. It was a comprehensive mitigating plan.
So aesthetics weren't their consideration.
Aesthetics were not part of it. No, sir.
Okay, and changing anything about this plan would
Start over.
Start
Yeah.
over.
I just told you
But
the
didn't
number
you
that
say
we
too
spent.
that move, and I know we talked about it, moving the groins or whatever you want to call them offshore doesn't meet the objective of the grant. Is that
This
right?
particular project had the groins are closer in because of they call it the fetch, the wave action. And so this particular project, the other projects there's another circumstance there. They had grasses that were growing and FEMA would not accept them destroying the grasses. So we had to go further out for those.
They did say at the meeting that breakwaters would work. The problem with that was not that it couldn't get FEMA's approval, but that it cost too much. It would cost probably $6 million instead of $3 million. to
I
use
have no idea
breakwaters.
about that. I
That's what they told me at the meeting.
have no idea. All I know is this is the plan that was accepted and approved, and this is
There is an
FEMA's.
alternative
Again, Judge,
presentation. Yes.
if I may, to accept the federal money to pay for the project, it has to meet all of their criteria. It's not a matter of what you want to pick and choose locally. It's a comprehensive plan.
Yep.
That's why they call it the BCA, the benefit cost analysis. There's an extensive algorithm and multiple data points. And if you don't meet all of those criteria, you're not going to score high enough to receive the federal funding. It's a very
Right, I
strict
wasn't-
process. So that's
I wasn't
why.
trying to say FEMA would agree to the bulkheads, just that the engineers indicated that bulkheads would work like a charm. They're just more expensive.
Well, that may be, but you would have to fund them 100% and not give
Right.
them federal
In
support.
Right.
in your handouts, you were given the first. I didn't bore you down with all of the algorithms and all of the math that went with it, but I gave you four front pages of the BCA, and in that BCA they talk about the comprehensive plan. They talk about this particular project being approved by NOAA as a way of mitigating against storms. And so I put that in there on purposely because I wanted you to see that that's why it got approved and what William just explained.
One of the other topics that I thought was hot at that particular meeting was the misinterpretation of ownership of
Right,
water land.
right.
Now, would you tell me a little bit about, just kind of explain, if you lose part of your land, how does the property rights go?
That is not, it's county law, local law, that's state law, or maybe even federal law. If your property erodes back, whatever the mean high tide line is at that point, is now the new property of the GLO or the navigation district, and in this case, waters of the US as well. The line keeps moving back. So as long as your shoreline is eroding away, that mean high tide line is moving back. And what Aaron was trying to explain to the crowd is once you start down this process, then they have to come back out and resurvey the boundary. And that's,
Yeah, it's my understanding that once that soil erodes, it becomes property of the permanent school fund, which is managed by the GLO.
right,
And you can't reclaim it without consideration.
right.
So, if they built breakwaters and that prevented erosion, that's going to help save the property owner's property, that's the land property. If they don't build a breakwater and it erodes, every storm, they're going to lose part of their property.
Most of those people lost a bunch of their property.
They
Last
were
week.
also raising the new concern, and that is if FEMA comes in and restores the shore and removes all that riprap and puts a sloping shore down with grass on it, and that extends the shoreline.
It's not
They
their
couldn't-
property anymore.
Exactly, it's not their property anymore. They're gonna lose the property.
It's
either
just,
way.
it's the property, once, prior to that project getting started, that line will be surveyed.
Let me give you a reference point, Wendy. In the 60s, when you hit the S curve where Ocasio Beach is, the land went straight ahead.
Trash.
I understand the risk of losing the property. I'm just saying they were told at that meeting they were gonna lose it either way.
Well, we were,
Yeah, no,
yes, the meeting, we
I'm just
were
talking about
basically,
the amount of the road.
we were accused of
Yeah.
being land grabbers.
Well,
It was exactly what it was.
All right, okay, all right.
Tommy,
I would recommend that you give the other entities the opportunity to mull it over and see if.
Yes, I think
they
it's
want-
time to think about the other entities involved and the people, matter of fact, involved. And
Because the
You know,
road
it's our
alone,
job
the
to-
road alone, the match on this grant is a bargain for redoing that amount of road.
Absolutely.
it's
It's your decision, folks,
so
whatever you want to
we've
do.
got a time deadline of the 14th. Is that right, John?
well, the 14th is the end of public input to the Corps of Engineers. Is that right? Let's give Commissioner Moore a minute to speak since his hand's up there and he's dancing. Okay, Charlie. All right, come on, Mr. Belair. All right, Mr. Belair.
Come up here, Charlie.
The Zoom people can't hear you unless you're at the mic.
Yeah.
One of
Announce
the
yourself, Charlie.
alternatives,
Tell them who you are.
I'm Charlie Belair with Belair Environmental. Been here 40 years and do a lot of work in the county for the county and all the other entities up and down the coast. Environmental work all on the shoreline and things. But one alternative that was brought up at the public meeting that ACND held was using articulated mat on the shoreline like there is at the refuge along the intercoastal waterway. And then there are 4 islands inside Mesquite Bay that we built back in the 90s and the last one in 2010 that have held up, some of them for 30 years and then one for we built in 2010. It's lasted till now, and I went out, we inspected it last Thursday and took pictures and sent them to some people. And it's built to plus 4.5, which is the elevation that the breakwaters are proposed to be at. And it held up very well. And it's an option that with the suggestion of getting the other entities to consider participating or taking the grant,
What
it's
would it
an
cost,
option that,
do you think?
pardon?
You have a cost estimate?
Yeah, it'd be, I got an estimate from a contractor and it's just under $1 million to use articulated mat instead of the breakwaters. That doesn't involve the road raising. So it's an option that if anybody who wants to see the photos or go out there, be glad to take them. But it's an option that should, I think, receive serious consideration because if start over means coming up with $58,000 to redesign or whatever it might be, it's something that maybe should be considered rather than sitting this on a shelf and not taking any action at all now on the project.
I just don't know, Charlie, whether those mats, and I'm familiar with the mats that you talk about. I got a neighbor that actually made them. And I don't know whether that solves or meets the criteria,
I don't either. Yeah.
the federal criteria for the grant anyway.
Yeah. But that's something that could be looked
I
at.
know, we could look at it. I would, at this point in time,
If we do that, we would have to expend on our side, someone would have to pay for all the re-engineering and the resubmittal of the BCA. And I doubt it would score well enough to achieve the federal grant. And it would cost another several months delay.
What would be the primary reasons it wouldn't pass?
because they're the feds.
Well, no, come
And they
on.
got
Yeah,
They got their rules
the
and they're
raising
embedded.
of the road.
who's got the
raising
gold rules?
That's exactly
Yeah.
right.
We
You
might
don't
have to
really
look
have to
at
give you a
the
reason.
road
Early
and
deals
other
with that
sources.
kind of stuff.
Wait,
Yeah. It might need.
Did you say raising the road?
That's part of the job.
Well, why would you not do that with an articulated map?
Because we
right?
can't get the money from FEMA just to do half the project. They want it all their way or not at
They
all.
want, if they raise the road, they want to protect it against further erosion. That's the problem.
Or articulated map would protect it from
And
further
William is saying
erosion.
they won't
But
buy
that
that.
wasn't approved.
That wasn't approved.
Can you go?
Yeah.
All right.
So FEMA didn't approve the articulated map through this process. Can they reconsider an alternative if someone pays for the cost of doing so?
Well, and Commissioner Moore is telling us that in a previous iteration of this particular grant, they did approve just that thing.
No, the core permit.
It's not to say it'll pass their benefit cost analysis, but it's at least something they've heard of before. It's not a crazy idea.
You would
You'd
think
think
so,
so.
yeah.
Worth pursuing.
Okay, well,
Well, it seems to me like right now, we need to set very soon, a sit down between Commissioners Court and all the entities, in a public meeting or whatever, but we need to sit down and talk about that because we're running out of time.
Correct. And there also is the cost of redoing all of this and the time it would take to do it. We've been waiting on FEMA approval since November for parts of this project. So if you go back and redo the engineering, you're going to cause significant delays, and then there's expense and who would pay for it. It would be a really challenging effort to go back and undo it at this point.
It's
well,
challenging,
okay.
but we can't go forward with this one.
well, one thing, the Corps of Engineers permit as it exists today does include the articulated mat, and it includes the breakwaters. So what's on public notice is an amendment that requests that the breakwaters be changed from the way they were aligned and the length of them that was in the original permit. But
it won't meet the federal scoring criteria.
but just talking about the August 14th deadline, it is to comment on the public notice. And it
Well, if it
doesn't
won't,
happen.
if it won't meet the FEMA requirements, it's,
Well, I still
agree with
think
you.
the biggest point is the grant is not going to let us spend any money to redo it. And I think that our position seems to be, if the other entities want to get together and fund that, I don't see why we would have any problem with it. And like I say, the match, if you look at just the road itself, I think the match is $190-something thousand. Well, the cost to raise the road is way more beneficial than what the match is. So I mean, I don't know if that's just what I think I'm hearing is that they, we don't have the funds and they won't expend it out of the grant to re-engineer or re-deal with the permit. So
Well, one thing about the re-engineering is that if that much money was spent on the data collection and the analysis, chances are that 80% of the data already collected could be used in the redesign, because you're not talking about starting all over from scratch. If they've got a project to the point that they're ready to prepare a bid package, they've got enough detail on the existing conditions to let an alternative be applied, probably.
Well, and another thing too, because it is you and your reputation around here, and a lot of us have dealt with you in the past and everything, and you have been very, very accurate in what you're saying. I don't know of a single time that you've ever been called to task on things that you've had to research, things that you've been wrong. I think right now the next step we need to do is within this week or as soon as we can get it posted and do it with all the entities that are interested. I think we need to have another meeting, and at that time we'll put an action item on the agenda to do something with this grant.
In order to go forward from today on this agenda item, to give the judge a chance to feel out the other entities, I'd make a motion to table Because
I'll
we will be
second that.
meeting each and every Monday this month.
I'll second that.
Motion made to table item number 4. Have a second?
Second.
Second, Commissioner Castleline.
Oh, right.
Oh, I'm sorry.
I
Again,
forgot her.
I apologize. I apologize.
Thank you. I attended the meeting at that the NAV district called. I don't live along Fulton Beach Road. I have actually no financial interest in that, but I was called by community residents and homeowners and just asked if I would please attend, which I did. I did not stay for the whole meeting, but I was there for the gist of the presentation, just left before maybe all of the final comments were made. And what I took away from that was no one disagreed with the fact that the road and some solution need to be infected for keeping the damage to a minimum. There was just great dissatisfaction with the lack of public input. And I know it's been said several times that there were many, many public meetings. But as I sat there and I watched Aaron Horeen, who's with Mott McDonald, give the presentation, the meetings that he mentioned were the Chamber of Commerce luncheon, the Republican Club. He spoke to the city council, I think he said in December of 2019. And then he spoke to the town of Fulton in January of this year with 100% documents, which doesn't exactly underscore true public meetings. There may have been more, and he just didn't mention them at that meeting. I'm just saying the overview was not a lot of public input, and there was just dissatisfaction with how the breakwaters were planned. There were different engineers there. One is a neighbor of mine who's worked for the Coast Guard for many years and also does contracting work with the petrochemical industry here and in Houston. And the concern was that the breakwaters really weren't high enough to affect any change. And since I think the water with Hannah went way over the breakwaters that they had in the Fulton Harbor, that seems like that's a valid point. So I just wanted to let you know what an objective person's view was of that meeting. Thank you.
Yes, sir. I'm not scared.
Tommy Moore, Aransas County Navigation District. First of all, the Navigation District is for getting that road fixed. We are in no way against getting that road fixed. What I hear today is that we're going to waste $280,000 on our engineering. This team never came to the landowner, which would be the Navigation District. They picked up a permit and they changed it. The permit had articulated map protecting the whole shoreline. Okay. We are for this. We will not be for any breakwaters. It has been proven over 50 years in the Aransas Refuge that you can break that water and then save your road. And the district would be happy to back this up a little bit, give us some time to get our feet on the ground. We could be convinced to go into it. He talked about the MOUs that they submitted that were just totally unacceptable to anybody. But I'm just saying, let's give us some time. This is a good project, and we truly feel, Charlie and I truly feel that we can get more of it done with the dollars that are left over and keep the permit as it goes. So,
Well, okay,
We
thank
have a
you.
motion on the table.
Motion made and seconded.
Oh, we have another speaker.
First of all, can we agree that,
Yep.
Say who you are, please.
pardon me, I'm Scott Heim. I live on Fulton Beach Road. Nothing would have stopped this last storm. We can take the damage off the table and go for lessons learned. It has nothing to do with anything except the future. Part of the problem on this is we, the landowners, were told repeatedly, you've been told about this, you've been notified. It's simply not true. Am I disturbing? I apologize if I'm saying something, but this is just fact. The issue of the land, you can't discount private land ownership. What I said in that meeting was the plan of what's known as living shoreline is to accrete marshland, and it is. And that will mean there will be land on the other side of private property that no longer belongs to the private property owners. There will be a piece in between their land. That's not a land grab, it's simply fact. And I think that people should be informed of the effect on their private property. And I think that most people believe that, except for the long-term recovery people. They did not notify us. They sent some notices to, all right, we're not going to discuss that. The plan itself, are you all aware that the actual shoreline itself, there'll be breakwaters and they will mitigate wave action. They will mitigate the amount of waves. But in a high tide situation, as was stated, the water will be over those breakwaters. There will be waves hitting the shoreline, and that shoreline will be protected by sea oxeye daisies only. Now, there'll be some seagrass if it decides to grow. Any place where there's not good coverage of the sea oxeye daisies, those waves will be hitting essentially unprotected shoreline and will continue. It's not a good plan as is. The articulated map would do that.
Okay, thank you. Motion been made and seconded to table this. All those in favor?
Aye.
Unanimous. Discuss, approve, disapprove, excuse me, amended resolution R 28-2020 to authorize the award of engineering services contract to Hanson Professional Services related to Rockport Center for the Arts, Public Facility and Parking under GLO Community Development Block Grant.
I objected to this at the last meeting, mostly because of concern about the lack of clarity of the wording. We're still using the term awarding a contract, and I think what we really mean is we're selecting a vendor. I understand that awarding contract is kind of another way to say that, but when we have a two-part process, one is we select the vendor and later we approve a contract, which hasn't even been negotiated yet. If we can just be more careful in agenda descriptions to say we're selecting a vendor, which is part of what the procurement process requires us to do first, and then later we will approve a contract after it's negotiated. The resolution itself says this and it's fine. I'm only bringing it up because the agenda description still, I think, confuses the issue. But with the change in the resolution's wording, I no longer have the concern I had at the last meeting.
So yeah, make a motion.
I guess if the record can reflect that it is clear the contract will come back to us for separate approval once it is negotiated. On that understanding, if that's correct, which I need confirmed, I will move to approve the resolution as currently worded.
Motion made. Do I have a second?
I need to hear first that we confirm that I'm correct in thinking the contract will come back to it for approval.
Correct.
Correct.
Okay?
Second.
Motion made and seconded. All those in favor?
Aye.
Unanimous. Discuss, approve, disapprove, authorizing county judge to sign an agreement for the professional services from Mott McDonald LLC for engineering, design, regulatory support, and construction administration services related to Cedar Bayou reopening project. Wendy.
My questions have been answered. I'd make a motion.
Anybody have
Approve.
Do we have that agreement?
agreements here?
What's the cost?
785,000.
785,000.
And
It's,
it's being
it,
funded how?
it's funded through the FEMA grant.
Do we have the
75% of the
agreement?
10% match is funded through the state. So the county's picking up 10%.
Do we have the agreement that you're talking about in the agenda item?
Yes.
In hand?
It's in your
It's in your
package.
package.
Where is the match coming from?
The match is, it's a 10%, it's a PA project, so it's a 10% match. The match is coming from 75% of that 10% is going to be picked up by the state. So we're picking up 25% of the 10%, if that makes sense.
Of the total.
And-
Total.
And are we funding that out of the waterways fund or we're?
The 20,000, where does that come?
You
Yeah,
know the
I'm
mon-
assuming it's coming, yes, wherever the judge is bringing it from.
It comes out of
Waterways?
waterways.
Waterways,
I didn't quite catch that. What is it, a waterways fund?
the waterways fund,
Waterway restoration.
waterways restoration.
We have a fund percentage of the hotel motel tax that we put in that for restoration of Cedar Bayou and other things.
I make a motion to approve.
I think Commissioner Smith made the motion.
Oh,
You second.
I second.
All those in favor?
Aye.
Unanimous. Discuss, approve, disapprove, and authorize the award of a 2020 hypervisor infrastructure replacement and migration bid for Waypoint. All right, Colin, what's this all about?
It's in the budget, Judge.
First thing we want to know is it's in the budget?
It is in the budget. This project is replacing some of our older servers that do this, pretty much the current tasks that these servers would be replacing. This is upgrading them for disaster resilience and adding some protections for failures and hardware failures that our current system does not have. And so pretty much we're replacing about 6 servers in across our network to operate our county infrastructure.
Is a hypervisor a server?
It's kind of a multiple servers in one. So it's virtual architecture. So we're running virtual servers on top of these machines.
Will this system actually help or increase our resistance to cyber attacks?
This will not, but it will allow us to keep up with current software. So we can get more security updates, but it won't in itself help with security.
So this is a routine replacement after a certain age. Like, take a motion to approve, Judge.
Motion made.
Second.
Second, Commissioner Castleline. All those in favor?
Aye.
Unanimous. Approve, disapprove July 2020 indigent healthcare report. Nothing out of the ordinary.
I make a motion to approve, Judge.
Motion made and seconded. All those in favor?
Aye.
Unanimous. Discuss, approve, disapprove, authorize the county judge to accept the renewal rates from Emeritus and for dental and vision insurance for 2020, 2021 plan year. No changes.
And I understand we're not changing the rates. We're just
Right.
renewing unchanged rates.
Right.
Policy's not changing any?
The county doesn't pay for that policy anyway, does
Now
it?
the people pay for
Pay
it.
people.
Oh, that's right.
Make a motion to approve.
Motion made and seconded. All those in favor?
Aye.
Unanimous. Line item transfer, we know what that is.
We have none at this time.
Motion to approve, Judge.
And say, all those in favor?
Aye.
Unanimous. Payroll, accounts payable, payroll, and payroll liabilities.
There was one payroll on this. For approval.
Move to approve.
Motion
Second.
made and seconded. All those in favor?
Aye.
Unanimous. Any reports? Okay, now is the time for any elected official or department head to bring up anything they might want to bring up to the public for our knowledge. Anything? Okay. Therefore, and because we don't have anything to go in a closed session, do I have a motion to adjourn?
Motion to adjourn, Judge.
Motion made and seconded. All those in favor?
Aye.
Unanimous. We have a public hearing in about 16 minutes. A public workshop, I'm sorry.
I think I have the address to that real estate. I think I got that. What was the cost of that money for you to do that? So I have a number on that, make a number. I don't have any audio. Insurance.
I'm sorry? What Zoom call?
We're here.
We're not muted.
I'm having problems with it. Here.
You have to do it together.
Hey. Yeah.
Okay, I have 10 o'clock, so I'll call the workshop to it. We're here to, and we do have a quorum. We're here to hear a report from Jerry Cox on the calculation of 2020 non-new revenue, voter approval, and dip tax rate, certified values by the chief appraiser. Jerry, you have the floor.
Good morning. I have given y'all all a copy of my memo, which provides the breakdown of the rates that we calculated. And the first section is for general fund, M&O, and INS. The calculated debt rate is 0.047037. And the no new revenue rate total for the general fund would be 0.360785. And the next section is for the road and flood. The flood debt rate calculated at 0.01082. M&O 0.061938. No new revenue rate for road and flood is 0.072758. So your total with road and flood and general fund is 0.0727543. So that's the total rate that you look at when you're proposing a rate. I think anything above that will require the one public hearing. And then I was directed by the court to calculate the 8% due to the disaster, and that because we have sales tax collected to reduce our property taxes, that gives us a voter approval rate overall of 0.464518. And with that, that's your benchmark. It tells you if you have to have a mandatory election if you go over, propose a rate over the voter approval rate.
Can you tell us what the number would be if it was 3.5 instead of 8?
Yes, I can. 3.5, your rollback would have calculated at 0.445174. And that is shown on the next page. I've given you 3 projections for budget reasons. And the first section is your no new revenue rate. And that is the same if you calculate it the 3.5 or the 8%. The next middle section is the calculation using the 3.5%. That 445,174, I just told you the total rate. And then the bottom section is the 8%.
Quick question. If we were to adopt the no new revenue rate, the 3.5% that has been waived this year because of the various calamities that we face, can that be carried to the next year under the law?
The 8%?
No, the 3.5. So we could actually go up 7% next year because we didn't use any of the 3.5 this year.
It is my understanding that you directed me to calculate the 8%, which throws us as a special taxing unit. That's the way we calculated, and special taxing units are not allowed to bank any unused increment rate. So no, you're not banking anything for next year.
Because we directed you to figure the 8%,
Mm-hmm.
and that changed our status.
Mm-hmm. Mm-hmm. That's the way I've deciphered the law. Now, if the court wanted to ask someone, a legal opinion, that's fine too. But
So normally, if we, let's say in a normal year, we were subject to a 3.5% cap. Normally, are we allowed to bank? Is that new under the new law?
that's absolutely brand new.
Okay.
Mm-hmm. Mm-hmm.
It was my understanding that us advising you to figure the 8% didn't have any bearing on 3.5 banking.
Whoops.
It's because the way it says that you're directing me to calculate, and when you choose that option, you're calculating as a special taxing unit, which does not allow to bank.
So
Well, I would suggest that we probably seek an attorney's opinion on it before, that would be for next year though, not this year.
And the commissioner's court
Fair
before
enough.
you have to direct.
Yeah.
Yeah.
Okay.
So that second page is giving you estimated tax levy on the 3 different rates and the budget amount. And I have a column that has the previous 2020 budget and the difference between the 2 budgets, depending on which rates are proposed. And the next 2 pages after that are letters. I'm required to certify debt, anticipated debt collections. And so that certification changes based on the amount that the auditor provides me, that we're trying to, what our debt payment is needed from the property taxes. This year, another change to that was, used to, you could do 100% certification anticipated rate, and anything collected over that amount was not reported as an excess. But Senate Bill 2 changed that, and now I have to go back and calculate the excess for the last 3 years plus this past one. So that's, instead of, you'll see I certified 108% and 113% anticipated collection rate. And that's because now you can go over 100%. You have to base it on what you actually collected.
Another quick question, Jerry, under the no new revenue rate, the 616,807 that's shown out, there's a difference between the 21 and the 20 budget. Did that all come from new construction?
Well, you get to add the new construction in.
I mean, where else would it come from now?
Right. And it's supposed to look at the properties from last year, same properties as last year and this year, and the 2 different values. And then as you calculate down, you'll see on the back page, I provided, or the whole next section after the letters, is the actual calculations that I did. And you can see how all those values plays out. But I do add that new improvement in
But
there.
basically, on a no new revenue situation, it takes out both the assessed value increases but it seems to me that 616 would relate strictly
Yes, you
to
do
new
get
construction.
extra because of the new improvements,
Okay,
because the new improvement value is backed out of the calculations.
So that would be the difference between 2019, January 1, 2019 and January 1 of 2020,
Mhm.
that we had enough new construction to generate that extra $616,000.
Mhm.
Is that correct?
That's where it's coming from,
Sure
yes.
hope it's correct. Okay, thank you.
I will tell you that the new improvement value was 146,289,754,
where's that, Joe?
and I'm looking at line 23 in the calculation, the first line 23.
Which page do you want to start?
I don't, it's the worksheets, the actual comptroller worksheets, line 23. And you'll see that is backed out.
So actually, the 146 that you talked about there times the tax rate of 43 cents comes up to 6.
I don't know, I haven't calculated that, but you can.
Jerry,
can.
146 million is,
146,289,754.
and that represents what exactly total?
That's the
construction?
taxable value of new improvements and new personal property located in new improvement.
And what's roughly the whole county property valuation?
Well, if you look at line 21, it's,
2 point, almost 3 billion.
yes. That's got some adjustments in there that we have to do,
Just
but if you
rough
wanted to
scale.
read all those lines.
Right.
Jerry, now, the new, you're talking about new structures, but also reevaluations are including the 146 million. Like, for example,
no.
somebody sells property and the
No, it's just
Just
that
new-
line explains
new footprint.
exactly what it is.
new footprint.
If
Pretty
you,
close, Jerry.
I'm sorry, what?
It's pretty close.
Is it pretty close? Good. I didn't bring a calculator. So that's basically my report.
Thank you.
Okay, I need to say now, I need to thank a bunch of people, Jerry being one of them, Anna, another, Jackie and Tana, much as that last one disturbs me to think. And of course, just kidding. No, I thank you for your hard work over the weekend and getting us this far. We really do appreciate it. And
And Judge, you know, these people worked over the weekend to get these numbers, which were needed. And at the same time, we have apparently some folks out there that, in my opinion, they were making decisions or making calls based on no numbers, just fearful numbers that they may have picked up from some of these things that were said in court, top to top. It's always the best practice to wait until you get actually good numbers from the folks that are charged with the responsibility of producing those numbers. For instance, there's been a rumor out there that, oh, borrowing X number of dollars was going to raise our tax rates and whatnot. Well, didn't come to pass. So enough said.
in fact, if we go with the no new revenue tax rate that is being proposed, our taxes will go down.
Almost 1.8 cents per hundred.
So anyway, that being said, is there any other discussion?
Sure, I'll add that the people that you're criticizing now are exercising their state law rights for an election
Right.
on a very
I don't have a
large
problem with
bond.
them
Excuse me,
exercising their rights,
excuse
but I
me,
think
on
they
a-
should wait
excuse
based
me.
on good
I was
information.
not finished with my statement. On a bond election, that's their right under state law. We really ought not to be criticizing them for asking for an election, even if we think they are mistaken about numbers that they're trying very hard to understand.
I'm not criticizing them for asking, but I made the point to one of those folks last Friday. I said, you should wait for the actual numbers before you start making claims.
All right, enough said. Any questions for Mr. Henderson since he's here and he can answer almost any question that goes with
Yes.
a number?
I have questions.
Yes.
Can you come up to the mic?
Budget questions.
When you gave us a presentation on July 13th, you were aiming at a budget, a bond process that dovetails with the budget process, and I didn't understand at the time exactly how that works, so I'm hoping for some clarification. I need to understand what part of, what do we have to achieve as part of the budget and tax rate setting exercise that I think has to be completed by August 31st, that, let me see how to put this, how does it dovetail with our ability to issue a bond at that same time? What I guess maybe another way to ask it is, what could we do after August 31st, if anything, to issue a bond if we can't make the August 31st deadline? How does that work with the
Okay.
budget and tax process?
Okay. First of all, the deadline is really not August 31st. That was a budget adoption schedule that the county had put in place from a state law perspective. And now I want to be careful. I'm not a lawyer. I'm not giving legal opinions. Nobody.
Sure. But what's the actual?
But the actual date, the county adopts its tax rate anytime it chooses to prior to September 30th. And the levy is effective October 1. So you have until October 1 or September 30th to actually put into place all the mechanisms required to adopt a tax rate and so forth.
But
What-
not, it is before the November election is the, I guess, the main
Well,
point I want to make.
Yes, but I guess there's two different answers to your question. The first question is, what do you have to do by September 30th to actually adopt a tax rate and levy a tax rate on October the 1st. And the answer with respect to the issuance of debt was that we needed to have the ordinance authorizing the issuance of the certificates of obligation actually adopted by the court so that by September 30th, so that it would be a legally outstanding debt and eligible for Jackie and Jerry to levy a tax on. So that deadline, September the 30th. Now, the second part of your question, if I understood it correctly, if I didn't, please correct me,
It was confused.
is that there is a November election. There's been some changes in the last couple of legislative sessions that have limited bond elections to only occur at uniform election dates. And we have uniform election dates in May and November of every year. They also have time frames by which that date, those elections have to actually be called. And for a November election, the latest date by which it can be called and meet all the publication requirements and advance notice requirements is August the 17th.
So if we wanted to put a bond election on the November election, we'd have to start by August 17th.
Yes, ma'am.
If we don't make the deadlines and achieve a November election, and yet one turns out to be required because the petition works, do we have any options for this fiscal year to issue a bond?
If an election is not called by August the 17th, and the court is forced to an election by virtue of a CO petition, the earliest opportunity to call that election would be May of 2021. And then we could issue the debt. There's a 30-day election contestation period, so we could probably issue the debt sometime in mid-June to late June of 21 would be the earliest time that debt could be issued following a May election, assuming that election passes.
Suppose one more scenario is, suppose we miss the November election and can't do this currently proposed bond in this budget year.
Mm-hmm.
Could we do a general obligation bond sometime next year? Or does that also have to happen? I mean, that wouldn't require, no, that does require. Could we do, I'm sorry, let me put it this way. Could we do a different new proposed certificate of obligation bond, perhaps not require an election? Can that be done this fall, or would that not work because we couldn't have folded it into the tax rate?
Here's the problem, difficulty, hurdles, however it is that you want to put it. The new legislation, and again, I'm not a lawyer. I wish that the county's bond attorney, Mr. Mendez, was here. But as I understand it, the new restrictions on the Certificate of Obligation Act place severe limitations on the county to move forward in the event of either a canceled issuance of certificate of obligation or a failed bond election. If a petition is submitted to the court that requires them to go to a bond election and that bond election were to fail, it would be 3 years before you could come back with another bond election, and the Attorney General's office during that intervening 3-year period of time would not approve the issuance of certificate of obligation. So if this petition that I'm hearing about, obviously I haven't seen the form of the petition, not a lawyer, don't need to see it. That's for lawyers to do. But if this petition is submitted and forces the court to go to an election, then the court's going to have that election. The earliest opportunity to do that is going to be May of 2021. If that election fails, you can't come back with another CO issue, and you can't come back with another general obligation bond election for 3 years, is the way I understand it.
No matter, it's not just a question of not being able to come back with one on the same subject. We can't go forward with any bond election on any.
Oh, no. Thank you for that clarification. No.
Let me suppose for a minute that there is a new CO proposed, and it's different enough to satisfy the state law, so that it's not considered just a rehash of the old one. Can that be done anytime this coming year, or does it have to wait until our next budget process so we can fix a tax rate to support it?
What I would say, Commissioner, is that as I understand it, the changes in the Certificate of Obligation Act have substantially raised the hurdle as to what constitutes a substantially different project.
I know, let's just pretend for a minute it's substantially different. Maybe we can't get there, but let's pretend for a minute we have a substantially different CO. Can we do one anytime during the coming year, or do we have to wait till next August to put it into the tax rate?
I think if it's a completely different project, you could potentially do it this year. Again, I'm not an attorney, but
So
this fiscal year.
It doesn't have to happen contemporaneous with a new tax rate dedicated to pay off the CO? Is that what you're saying?
Well, the CO debt or any kind of debt, whether it's CO debt or voted general obligation bonds, has to be outstanding at the time that you levy the tax, not the time you set the tax rate. And that's the difference, is because you might set the tax rate. For example, the numbers that Ms. Cox has provided to the court anticipates the issuance of 19,900,000
The
before.
bond has to predate the tax setting. The tax rate setting does not have to happen contemporaneously with the bond. Is that right?
If I'm understanding I'm not sure I'm understanding your question
The
correctly.
bond has to be in effect before you can set the tax rate, but the tax rate does not have to be set at the same day you do the bond. It could
No,
be
that's
4
right.
months later.
You set your tax rate in accordance with your normal budgetary process. The debt has to be legally outstanding at the time you levy the taxes, which you levy on October 1.
So we could conceivably, in December of this year, issue a bond and not get around to setting the tax rate to support it until next August?
That's correct, but I don't understand the context in which you're asking the question, because there wouldn't be a debt transaction in December. We're either going to do the certificate of obligation and have it approved by the court before September 30th, or we're going to be forced to an election in May of 21, in which case, if the election passes, we wouldn't be issuing debt till June, July of 2021.
Right, because the next available election will be May. We know that the next time we could actually float an issue would be June or so.
Yes, it'd be 30 days after the May election.
Okay.
And again, I want to clarify, because I've heard some talk about, a substantially different project. Not only would the number of the debt have to change substantially,
But the use of funds.
the use of funds, you would have to find a whole different location, physical location for the courthouse. It would have to be a very substantially different project. Could not be done in conjunction with Celebration Station or the City Hall project. It would have to be substantially different. And I would advise the court as a whole that it would really put this community in a serious bind if this petition is filed and that election fails, because it would put the court and this community in a position where it could be 3 years before it can be put back to the citizens to do the courthouse in the same location that's being contemplated now in conjunction with the City Hall and so forth.
And that restriction applies not only to a new CO, but a new general obligation?
Yes,
bond?
ma'am. Yes, ma'am.
Well, they've got, I think, 500 signatures. They only need about 850.
Well,
and they have only
I
been at it
hope-
for 2 days so far.
I hope that with this new information that the debt tax rate would fall a half a penny as opposed to the multiple penny increase that's been discussed in the community. I would hope with that the organizers of this petition would consider not submitting the petition. And I would also hope that the citizens, I would bet, and I don't get to vote in this community, but I've owned property in this community since 1984. So I am also a taxpayer in this community. And I would hope and expect that probably a whole lot of those 500 people that signed that petition have done so under false pretenses. And, they were induced with false information. And I would wonder how many of them would sign the petition after knowing what the actual facts are.
I don't know that it's false information. I think
Inaccurate information.
Because
I stand corrected,
I
Commissioner.
agree.
You're correct.
False is the wrong way to put it.
You're correct. Inaccurate is a better way to put it. I stand corrected.
Bob, I don't know if I have this, if this question would be for you or Jerry or both. Is there a difference, a CO versus a general obligation bond on the taxes that a person that's taxes are frozen pays?
No, sir. People whose taxes are frozen are not going to see a tax rate.
No matter which kind of bond it is.
You know what? I'm going to stand corrected a second time, but Judge might better write this down. This is the second time I'm going to stand corrected. Actually, because the debt rate is falling, if the county were to adopt a tax rate, debt and general fund together, that is less than the nominal rate we had last year, even people whose taxes are frozen would see their tax basis, and I know I'm reading Charlie's mind here.
It's a one-way
Their
freeze.
taxes are frozen unless their new valuation, the combination of their new valuations and the new tax rate lowers that threshold. There are circumstances under which people who pay frozen taxes can see their frozen tax bill fall, but it'll never go up under any circumstances.
The reason I asked the question is, in the back of my mind, when all this came up, I was thinking that I remembered something that there's a way that their values can be increased by certain types of bonds that are added or voted after.
No, sir. There's no circumstances in which that can happen. The only time that a person who's over 65 taxes have frozen because they're over 65 is if they do a substantial improvement to their property and they have reevaluations of their property. Other than that, there's no opportunity. No amount of issuance of debt is going to change a frozen tax levy.
Well, and a change to their actual value of the property wouldn't really affect the tax rate as much as just the value that the tax rate is being. And it's not going to raise their tax rate. It may raise the amount of taxes based on improved value.
It'll raise the amount of taxes based on the improved value. That's correct. Yes, sir.
So if I understand this correctly, if the petition is successful, we're required to hold an election. We cannot do it before May. The first time if we succeed between now and May in persuading the public to vote for this bond to build the courthouse in whatever final amount we set the bond in by the deadline, then we could issue this debt next June or July.
Late June, it has to be at least,
I'm just saying the only way we're going to be disqualified from ever doing a bond on the courthouse again is if we lose the election in May.
and then, not ever, but if
3
we
years.
lose the election in May, then you would have to wait 3 years before you could call another bond election for substantially the same
Right.
project.
But that won't be a problem for us if we use the time between now and May to get the public on board to support the bond.
If that's necessary.
It does cause delay because we would rather borrow now and not next June, but it can be done next June or July.
If the election is positive.
Right.
But I want to answer your question. Again, I'm out here practicing law without a license. I'm not a lawyer, everybody. But as soon as we can issue that, you're going to have an election in first week of Tuesday, I think it is, of May. Then you have to canvass the election returns. That generally takes 8 to 10 days to canvass the election returns. And then you have a 30-day election contestation period after that. So that's why I'm saying mid-June.
Right, sometime in the summer.
Yeah, so if we have the election May the 4th or something, the canvass election returns 10 days later, May the 14th, then it would be June the 14th before we could issue debt.
What's the last day a petition of any kind like that deal could be accepted by the court?
17.
It would be presented to the last day would be the anticipated date that you adopt the ordinance of the certificate of obligation, which was originally scheduled for August 31st.
And we can't move it earlier than that because we had a 45-day notice period to adhere to.
Right. I mean, the court,
I mean, it could be later, but it can't be earlier.
No, it can be earlier, but it can't be later.
We can't make it earlier because we have a 45-day notice period, which we only published on July.
Oh, you
15th.
mean we can't make it earlier in terms of issuing the debt? Right. We cannot move the debt issuance up. The petition could be submitted earlier, but you cannot move the debt issuance up for exactly the reason you state, the 45-day publication
So
requirement.
the deadline for presenting the petition to us, therefore, is before the August 31st.
That was the original date of the 45-day notice, yes.
And if we moved that date later, the petition date would be later, but we can't make it earlier.
Right. Can't make it earlier.
Any other discussion?
Judge, this is
I guess-
Michelle. Can I say something?
Yes.
Okay, as far
Yes.
as the August 17th deadline goes, the petition would need to be submitted to us sooner because my office would need to certify it by that date. So it's not a matter of signatures being turned in on the 17th. The signatures would need to be turned in sooner to give us ample time to certify it. The 17th is the date to certify the election, not the actual deadline of signatures, if that makes any sense.
That does
But-
make sense.
So it'd have to be on-
Is that even, I mean,
before the 17th.
I thought the August 17th deadline was already moot in this discussion. Is
No.
that still
Well,
live?
the August 17th deadline is the last date under state law under which you could call a November election. And what Michelle is pointing out is
It'd be a
that
little earlier
once the
than that.
petition is signed, it's her job to validate it. And the way that you validate it is confirm that the language in the petition is correct and that the signatures are valid signatures of valid registered voters.
If we call an election by whatever this deadline is, it's somewhat before August 17th, do we still have open to us the option of getting this bond proposal approved in the November election, or is that a dead letter?
No, if this court were to decide to call a bond election before August the 17th, we could meet a November election.
And we can do that either because somebody has given us a petition or just because we decide to? Do we have to have a petition or can we just do it?
That's a two-part question. I think the answer is that the court could decide to call a bond election. What I'm not clear on is what happens with the notice of intent that that the court has already given with respect to the certificates of obligation. I don't know what the legal procedures or options are for canceling that notice because you've already given it. And that's where I would really need Mr. Mendez's legal input.
So there may be still a path to a November election that allows us to obtain this funding this year if we get the voters on board, but we're not sure yet because there's some problems.
Well, I think that the court would have the latitude to call an election if they took action by a November election, if they took action by August the 17th.
Or a little earlier.
Or anytime
satisfy
earlier.
Michelle's issue.
But I don't know what the legal standing of the certificate of obligation notice of intent would be. I need a legal opinion on that.
Okay. Bob, basically, when we issued the notice of intent, that didn't bind us in any way based on what you said on that.
That's right. It did not bind you to issue the debt, but it
Preserve
may very well bind you to take action one way or the other
right.
to not issue the debt. And I think it's an important point.
The court could always call for a bond election. And the only restriction there would be based upon the timing to get it on the election.
Right. And on that point, Commissioner, as you know, because of the discussion on the Commissioner's Court that day, July the 13th, I think it was, we gave notice of intent to issue up to $24,250,000. And since then, the court has gone through their workshop areas and they've settled on a number of $19.9 million. So you can certainly issue, again, less than the 24.2 that you talked about. And I think everybody's clearly understanding we're talking about less than $20 million now.
Yeah, this is the point. Those were all preliminary numbers. They were numbers that just came off the top of what some people, I think you were asked that day, how much additional money could be, another $10 million. Well, so many people may have taken that.
Right.
To represent that we were going to borrow an extra $10 million.
They absolutely took it as what they were exposed to as a threat. You bet.
And
they still do.
Well, it's unfortunate that, I would hope that as elected officials, the community, the fact that you are elected officials would demonstrate a level of trust that the community has in you. And so I think when you make the pronouncement that it's going to be $19.9 million and not 24, I would hope that the public would understand and trust that. And then back to your point, Commissioner Smith, is that, yes, they said, how much would $10 million? I said, well, I think we can do it for less than a penny. Well, as it turns out, with all, because we're not issuing 24 million, we're only issuing 19 million. And because of some other, we turned in a growth of the final certified tax numbers of the county has come in since that date. They came in on the 25th. We showed 9.92% growth in the tax base just by coincidence. And I think Ms. Cox's numbers show this. The debt rate that she's calculated based on information that Jackie delivered to her shows the debt rate declining 9.93 cents and the tax base went up 9.92 cents. So coincidentally, percent, right. What did I say?
Cents.
Okay. Cents. I'm sorry. I know a lot of people like to catch me on that.
Does that mean that the 0.6 cent increase that we heard earlier is a possible estimated tax rate increase to service the entire 19.9 million is now become a negative number?
Negative half a penny. It's
So
going to go from,
about negative 0.5?
yes, it's going to go from 0. Well, let me get my percentages and my cents correctly. Last year, your debt tax rate was 5.225 cents.
Mhm.
Now we're looking at 4.7038, I think the number is. So it's very slightly more than half a penny Did I get that correct?
3.7, not 3.8.
3.8. Well,
3.7.
come on, we're 6 places past the decimal point. Give me a rounding spot there.
You're all right.
So we're talking about a full half penny reduction in the debt rate, even with the issuance of the 19 million nine. And let me explain briefly why that happens, because I can see the confusion, and it's perfectly normal to have that
I'm
confusion.
not confused. I'm looking like this because I want to just clarify that I've got it right. So when I write it down.
Okay, sure,
tell people
okay.
I got it
No,
right.
no offense,
If we
Commissioner.
manage to get this $19.9 million bond through with all the obstacles in its way,
Mhm.
we are telling the voters, the taxpayers, that we will actually be able to reduce their tax rate this year by half a penny,
The debt tax rate by
not
half
the
a penny.
overall tax rate.
Now, the
necessarily.
overall tax rate depends on what the court does.
Okay.
Well,
But
'Cause there's-
just the part relating to debt, we can go down half a
The
penny.
part related to debt could go down 1/2 of a penny.
Commissioner, if in fact we were to go with the no new revenue rate, our tax rate, overall tax rate would go down
Could do. It
1.79 cents.
It just depends on what we do. But the debt component of it
Would go
will be
down half a
contributing half a
penny.
penny. How much would the debt rate go down if we just refinance the 3.5 million that we're talking about refinancing and don't do a $19.9 million bond?
Well, the interesting thing about the 3.45 million that we're talking about refinancing, those are the certificates of obligations of 2021,
Uh-huh.
and they were related to road and bridge. So we're going to save, the market stays with us, we're going to save about $47,000 per year. That would equate to about 0.0017, slightly less than 2/10 of 1 penny. But that's paid out of the road and bridge fund. It's not paid out of the INS taxes. So it's not going to impact the INS taxes one way or the other.
So what you're saying is, even if we take on almost $20 million in debt,
Mhm.
how is it that the tax rate goes down? Is it because values have increased?
It's a combination of
appraised
things.
values
And that's what I was
dropped.
referencing a minute ago, because the normal person would go, how do you issue $20 million in debt and not have an increase in the tax
Right,
rate?
suppose the values just increase and we don't issue the 19.9 million. How much does just the increase in property values decrease our tax
Okay,
rate?
well, let me give you a little background. I will answer that question, but let me give you just a little bit of background. As we talked about in July, the debt that this county has is not only extremely modest, very low, but in fact, it's very short. And the problem that we've had with the tax rate impact of any debt issuance is literally just the first 4 years. How do we get from 2021 to 2025, where we've got this modest amount of debt that pays off quickly? How do we get past that? Well, there's 3 things that's helping us get past it. First of all, is the growth in the tax base of 9.92%. That's a big one. The second thing is that we are able under state law to defer principal a little bit. We're not deferring principal entirely, but we can defer principal some and pay largely interest only until we get to that past that 4-year spot. And then the other thing is that the county has very prudently built up interest and sinking fund balances, surplus balances in their INS account. And we are going to be able to use some of those surpluses to help mitigate this tax rate during that 4-year period of time. And I will tell you, I'm going to digress to Ms. Cox's presentation. One of the main things that Senate Bill 2 did that is really disadvantaged all the public entities in the state of Texas, cities, counties, schools, everybody, is this whole concept of certifying a tax collection ratio based on previous year's excess collections. You know, and she didn't go into a lot of detail. I will. She's had to certify 108% tax collection ratio for this year. And you go, how do you collect more than 100% of taxes? Well, the reason that she's had to certify 108% is because last year, because of the new growth values that Commissioner Smith was talking about, you had excess collections of $95,200 something dollars. She has to fold that back into the tax rate calculation. And that ends up a large part, that in the growth in the tax base ends up in a large part of why you have a certified collection ratio of 108%. Conceptually, I can understand why the legislators and all legislators in Austin did that, because you say, well, you don't want to have, double dipping of the tax rate. True. But a community like Rockport, Aransas County, needs to have a surplus fund balance in their INS account and indeed their general fund. And this is one of the things that you're going to have to talk about when you adopt either 3.5% or 8% or some number in there, whatever the court does. You've got to maintain a substantial amount of fund balances just for events like Hurricane Harvey. Even this pandemic has created problems with hotel occupancy tax collections and sales tax collections. So you need some fund balances. The problem with Senate Bill 2 across the state is that it's going to not only eliminate the opportunity for communities to build up fund balances in their INS account, it's actually going to reduce those fund balances and limit the latitude that communities have to deal with
Let me
emergencies.
interrupt you for a moment because we've wandered far afield from my question and I still need an answer to it. Given the $3.5 million that we plan to refinance and given the fact that property values have risen almost 10%, if we don't borrow almost $20 million in this CO, how far can the tax rate drop?
It would be about the same amount of money, about the same 4.7 cents. And here's why. Because I would not advise as the county's financial advisor, and I don't think the court would want to use surpluses, some of these same INS account fund surpluses to reduce that tax rate.
Suppose we did, what could the tax rate drop to if we did all the same things except the $19.9 million bond?
If you did all of the same things except for the 19.9 cent, somewhere between, I haven't massaged the number since we were coming at it from a different angle yesterday, but my guess would be 3.5 cents.
Lowered.
No, not lower. Instead of being 4.7 cents, if we did all of the same things with the fund balances, probably 3.5 cents instead of 4.7 cents.
Okay, so 1.2 cent decrease.
This year. It may have to go back up next year.
Instead of a half cent decrease.
Yes.
So another 0.7 decrease for the bond component. Okay.
You know, Bob, you amaze me with your knowledge and whatnot to be able to stand up and answer those questions. I would point out, though, that having a courthouse, a place that we have a judicial system, among other services that we are required to furnish to the public, it's not, it's not discretionary. It is required. So whether we spend X number of dollars to build one facility or X number of dollars, we still have to build a new facility. We sustained a humongous loss in Harvey down here because all of the mitigation from the government, federal government, does not reimburse counties or cities to replace either their city halls or their courthouses.
Or police station.
Or their police stations. That's considered a general government function. So, yeah, we took it on the chin from Harvey, and nobody's going to get us out of that other than ourselves. So our plan to go forward out here has been based on how do we do it where we protect the taxpayers as much as possible. And I think the plan that we've come up with is a good plan.
You may or may not know that I actually teach public finance at Texas State University as part of their Certified Public Managers program. I've been teaching this. I've been in this business for 37 years. I've been teaching this for 25 years.
Yeah, but it changes overnight every time the legislature meets.
It does. It changes a lot. But the question that you ask is a good one. And I had a very lengthy discussion with the Commissioner's Court of Bandera County about what is the definition of good government and when are elections advisable from a good government perspective, and maybe when are certificates of obligation that don't require an election a good alternative for communities. And it really gets to exactly what you're talking about, Commissioner, the difference between things that are mandated by the state constitution that the court has to provide its citizens, such as law enforcement, court systems, record keeping, and the like, versus things that are nice to have, but are not mandated by the Constitution. Things such as senior citizen centers, community centers, parks, airports, and so forth.
Third floors for new courthouses
Well,
are not mandated.
It's a matter of required square feet. It's a matter of, do you need the square footage? It doesn't make any difference in my opinion if it's on the third floor or do you just spread out the first floor more. You need X number of square feet. But and for cities, for example,
doesn't guarantee us 55,000 square feet.
For cities, for example, one of the things that was a real sticking point in legislative history was back. I know Bird's eyes are glassing over because he's heard me talk before. But, back during the Depression, we first started the Texas State Health Department. And we started to put in requirements for the quality of potable water and the necessity for sanitary sewer systems. But all of the elections, all the debt issuance at that time was required to be done by general obligation bond elections, or they did also have revenue bond elections. So what happened was that communities were being mandated by the health department to do this, that, and the other for their sewer system and for their water system, but the bond elections were failing, and the cities were in this situation where we either violate this law or we violate that law. And that was the genesis of the Certificate of Obligation Act, was to give cities and by extension counties the latitude to finance those items that they were constitutionally required to finance. Now, it does have a petition thing in there in the event that the public doesn't trust their elected officials. So there's a petition to force it to an election. But that's the whole history behind the Certificate of Obligation Act, is to give communities the opportunity to meet their constitutionally required duties without having an election.
Either way, they were going to try to meet their constitutionally mandated duties. The question is, were they going to convince the taxpayers to go along or fail to convince the taxpayers to go along? And what you're describing is a law that says, if you can't convince your taxpayers, we will allow you simply to ignore them.
No, I think what happens is, no, they're not ignored. They're not ignored under the Certificate of Obligation Act. That's what the petition requirement is for. So they're not ignored. There's either an active approval of the debt through a voted bond election, or there's a passive acknowledgement and approval of the debt through a failing to act on a petition option. I think the problem that communities had then, and some communities still have, and this is not, look, I'm not going to blow smoke up anybody's skirt, to use my grandmother's phrase. A courthouse is not the same thing as a potable water system. I understand that, but it is a mandated requirement, law enforcement, record keeping. There are certain things that the court has to do. If the voters of this community feel like that the scope of this project is so vastly beyond the actual need of the community, sign a petition. By all means, and take this thing to an election. It's not for me to decide whether 45,000 square foot is adequate to the county's needs, or 53,000, whatever the number is. I'm not familiar with that side of it. I just do the money side. That's up to this court to decide, and then by extension for the community to decide. It's not for me to decide. I just feel like that when I'm asked the question, when is an election appropriate, or when is it maybe not necessarily required, my standard answer is, if this is a function that the government is required to provide, water and sewer if you're a city, law enforcement, courts, record keeping if you're a county, if it's required to do it, even as a conservative Republican good government guy, I'm okay with certificates of obligation. Now, if they want to go spend $40 million on a civic center, if they want to go build a $20 million green space out, there, then I'm going, wait a minute, we don't need it. Do we need a $15 million library? I want to vote on a $15 million library, because libraries, civic centers, parks are not constitutionally mandated. So that's my answer to your response.
Thank you.
And Bob, we're not, if we would issue COs, we're not bound by the 19.9 or whatever. If we choose to go for a lower number, that's still open.
That's correct.
Anything under 24 million.
Anything under 24,250,000, the court has the authority to say yay or nay to, but you cannot.
A lot of time in conversations, it makes people think, I think, that you're set on that number,
Well, I personally, I wish, it's all 2020 is always hindsight, I wish that we had better information available on July the 13th, so we wouldn't have had to give notice for 24/2 just to buy more time.
Or start in January. July was way too late.
I wish we'd had better information on July the 13th, but it wasn't there. I think this, again, I'm not a lawyer. I wonder, I would think that this court could adopt some public resolution limiting themselves to 19.9, but I'm not a lawyer. I don't know.
Again, thank you, Bob, for all your input. We appreciate the new knowledge that we have gained. Are there any other questions or discussions? If not, I entertain a motion.
Motion to adjourn before discussing other budget matters.
Is there any other budget? I'm sorry.
Well, it's, what we have on our schedule is next week on the 10th for you all to propose the tax rate. I wanted to show you what
Okay.
just no new revenue would do to the general fund. Right now, it still has the current rate. And our fund balance with just doing the no new revenue rate would bring our deficit down to 661,000, would leave our unrestricted or unreserved fund balance still up plus of 6 million.
Let me make sure I understand that. If we adopt a no new revenue tax rate, we can leave our reserve balance at around 6 million?
Well, we would still be approving a budget that had a $600,000 deficit in it. But there are some other things that we need to talk about probably this morning, and I'm glad the sheriff is here. I know that for the last almost a year, we've been trying to get an increase in our jail rate. And where do we stand on that, Sheriff?
Sheriff, I don't think people on Zoom can hear you, even though we can, unless you stand to the microphone.
In the last 2 months, we've really been trying to push the issue, and I did contact a lady in Washington that's handling this, actually the paperwork. They've been working out of office for a while. It did require a letter of justification by the U.S. Marshal in San Antonio. And ironically, on the day that we ordered test kits for COVID, he called challenging the rate that we were asking for because we weren't in a position to test when other facilities were doing that. And I told him we had ordered kits that morning. They were overnighted, came in Saturday, and we conducted COVID tests of the employees and the inmates in the detention center. He said it made it easier for him to write a justification letter, which he was responding back to Anisha. He got that done. I contacted him last week, asked Anisha where we were at. She'd just come back to the office, had 2 questions, and Jackie submitted replies to her on Friday concerning things that we had not requested increases in, and she was just wanting to make sure that we were good with that.
Are you talking about increases in what the feds pay us to house their inmates?
Yes, ma'am.
Okay, thank you.
Last time it was negotiated, I believe, was over 6 years ago. It's a 5-year contract. We were well beyond that, but the time that we initially started trying to do it, this request has been lost. It got locked up in their system. We have been dealing with, like Commissioner said, for a year and a half trying to get this thing moved. Last week, she told me that she was forwarding it to her supervisor and would have a reply back in a couple of days, expected to call us at that time on Friday or Monday of this week to sit down and have a negotiation. So I expect a call or an email anytime this week, and then we'll talk about a rate.
We were asking for about a $20 a day increase, went from 63 to 83, something like that. Is that right?
Higher now?
It was over $80. 83 sounds about right.
So how much annual new revenue would that generate if you got that?
I can answer that for you, Commissioner. It's about
Okay.
$640,000 a year.
Okay, so if this works out, we might have another $640,000 added to the budget.
Good, yes, ma'am.
mean,
But
to
that's
the
based on
revenue.
daily rate that fluctuates as well.
And that's
As
based
far
on
as the-
90 prisoners, federal
Like I
prisoners.
said, we try to set a target at the first of the year. That is a moving deal.
Yep.
Right now, the feds are dropping their populations all across the facilities because court action activity, they're just not picking up as many people right now, but that's typical in law enforcement because of COVID.
I keep telling everybody out in my precinct, don't want to arrest them because you have no place to put them.
Oh, I've got beds. It's just the intake process, the screening that we're going through, and we look a lot at warrants and where they're coming from. If it's a 6-year-old warrant, do I really need to justify the risk? Or is this person going to come up at another time, another place? We completed the testing of all the facility last week or week before, and the employees that submitted to the test. Did have one inmate that did test positive. Ironically, we had brought him into the facility the day before on a blue warrant, which I had held off on. But because of his behavior and activity, we needed to place him in the center, and he's the only one that has tested positive. But he's been held in isolation, and we don't foresee a problem with that.
I have one more budget tax question, but it's not on your jail issue.
Thank you, Sheriff.
Thank you.
I understand, we're talking about a no new revenue tax rate that would result in a deficit, but leave our general reserve balance at around 6 million. I understand that's not the same as not changing the tax rate, right? What change in tax rate would we need to get to the no new revenue number?
With what Jerry has calculated, your no new revenue rate is 0.433543,
Which is
1.8 cents lower than it was.
Yeah, 1.8
1 point.
cents.
Okay, so
It's a reduction in the tax rate.
okay.
Well, I would like to see you come back next week when we have this with assuming that we're going to get more revenue out of the feds here. Even if we budget the full 600 and some odd $1,000 and we only get half of it, we'd still be probably $300,000 over the $6 million floor on our general fund balance, rainy day fund. Which I'd hate to see us go below the 6 million. And the judge likes to keep as much money in hand as possible.
Yeah, we found out 3 years ago that having that fund was quite helpful.
Yes, sir.
Particularly when we have to pay and get reimbursed. Yeah.
Yes.
No kidding.
All right, any other discussion? Any other thing need to be brought up? Yes, sir.
Your current consideration of budget, I see salary, but that's to compensate for additional payments you're in here. I'm going to ask you to really encourage you to give consideration to a raise. Before in this county, I don't think you had a raise for 3, maybe 4 years prior to starting. It's an expensive place to live, and I'm losing officers again like I did in the cycle 5 years ago. They're going elsewhere because the pay rate is better.
Didn't we do cost of living raise last year? But you want it above cost of living. I got you.
Okay. Yeah. All right. No other discussion now. There was a motion in a second, wasn't there? Or was
I
there?
haven't made a motion. But
All
I
right,
would make a motion.
make a motion now. A second, Commissioner Castleline. All those in favor?
Aye.
Unanimous. Thank you.